I call the Honourable Member Carmel Sepuloni.
Mr Speaker, as my colleague Charles has spoken of, we do have concerns about the government's overall direction with regards to its justice policy, which inhibits access to justice, Mr Speaker, and creates the potential for substantial miscarriage of justice. So, Mr Speaker, for that reason, and I'll explain in more detail why, but for that reason, we will not be supporting this bill. Labor believes in an accessible justice system, and we do have serious reservations about the direction of the reforms in the justice system under this government. This bill essentially rolls back the expansion under Labor in 2007, making it harder for people to access lawyers. At the time, legal aid had not been reviewed in 2 decades, and the then national opposition criticised the Labor government for not making enough legal aid available. Labor introduced a new repayment and debt management scheme, which is where the focus on sustainability should be, rather than penalising low and modest income people who genuinely, Mr Speaker, need a lawyer and need to be able to access legal representation. The changes are to encourage legal aid applicants to consider whether they wish to proceed with litigation. This may dissuade people from pursuing a justified case, limiting a person's right to access to justice. The current means test will be modified in the case of offences that are not punishable by a maximum term of imprisonment for 3 years. The Minister has indicated that the threshold will apply to those earning $22,000 for a single adult and $51,000 for an adult with 2 dependents. $22,000, Mr Speaker, is not a lot of money. So to deny anyone that was earning $22,000 or over does not seem, on this side of the House, to be very just, Mr Speaker. In fact, we fear for their ability to get representation for themselves with respect to the legal matters that they may be confronted with. What we're concerned with is that this may force people into representing themselves in court, increasing the chances of miscarriages of justice, Mr Speaker, and I'm sure that other members in the House would agree that your general everyday Joe blogs wouldn't necessarily have the skill set to be able to represent themselves effectively in court if required. The cut to legal costs by significantly expanding the public defender service at the expense of independent lawyers providing legal aid is a concern to us, Mr Speaker. The latest review of the public defender service in England and Wales showed that the Minister's solution to expand PDS will cost the taxpayer considerably more than it does currently, and Mr Bridges probably doesn't recognise that often in these matters research is required, and we do look overseas for examples, which is what I was just citing, Mr Speaker. While Labor supports the existence of PDS, or the Public Defender Service, as it was initiated under us, Mr Speaker, we believe that independent lawyers should provide the bulk of criminal defence work. The lack of balance in what the Minister is proposing will lead to a lack of quality in terms of legal defence options for Kiwis facing charges. And, Mr Speaker, the quality of our justice service is certainly in question after 2.5 years of the national government being in charge. Furthermore, the government's plan for the Public Defender Service, along with the denial of those charged with a Category 1 and 2 offence to choose their own lawyer, restricts choice for individuals. Those who have a history, particularly in mental health issues, may be forced to have a lawyer who does not know them, the disadvantages they face, or the full state of their circumstances, and perhaps won't have enough time to investigate in order to provide a comprehensive defence. The Minister, Simon Power, has not made the figures for actual costs, including all administration setup and expansion costs, available. There needs to be greater transparency to improve access to justice for all New Zealanders, and unfortunately, we're not seeing it under that national government. The Ministry of Justice asserts that criminal legal aid is the highest expenditure area and is steadily increasing. However, criminal lawyers are really the initiators of legal actions. Therefore, if there is increased use of legal aid lawyers, arguably it is also because number of charges in summary and indictable offences has also increased. When the legal aid reforms were announced, Mr Power said we cannot continue to ignore the substantial cost pressures the system is facing, particularly at a time when New Zealand is being forced to borrow an average of $300 million a week. The government gave $2.5 billion in tax cuts to the top 10%, Mr Speaker. I think we need to keep that in mind in light of Simon Power's statement. The government gave $2.5 billion in tax cuts to the top 10%. Meanwhile, people earning over $22,000 now will face tougher access to legal aid, even if faced with a criminal charge. And I think we are seeing there again, Mr Speaker, where the government's priorities lay. The money could have been in place to ensure that justice is accessible to all Kiwis, to all New Zealanders, but instead now they cite reasons of financial difficulty and the fact that we are currently borrowing so much money as a reason to cut access to justice for the vast majority of New Zealanders, actually, and yet they still can give $2.5 billion in tax cuts to the top 10% of earners in this country. And again, Mr Speaker, I say that really does show what the national government's priorities are. Implications for those charged and facing bail are that duty solicitors will only apply for bail on behalf of a defendant in a Category 1 offence. If a defendant is waiting to get legal aid or can't get legal aid, they may not be able to have successful bail. Innocent people may have to spend some time in jail because of the timing of the application while their access to legal aid is being examined. The purpose for the merits test for granting family legal aid is to encourage parties to resolve more minor matters themselves, Mr Speaker. Most parenting applications already require parties to undergo counselling and mediation before there is a hearing in court. Legal representation ensures that parents are aware of all of their legal obligations. The changes to legal aid provisions to deal with the rising costs of family legal aid grants disregard the changing landscape of families in New Zealand. So we do have some major concerns, Mr Speaker, with the legislation that we have before us. As I said at the beginning of this bill, we will be opposing this bill, Mr Speaker, because of the concerns that we have about the government's overall direction with regards to its justice policy, which really does inhibit access to justice and create the potential for substantial miscarriage of justice. And that's what we will be looking down the barrel of going into the future if this legislation is passed, Mr Speaker. Overall, I mean, the subject, in terms of this bill, the bill amends the Legal Services Act 2011 and other acts to limit the number of legal aid grants and increase the amount legally aided people must pay. The bill also limits eligibility for legal aid, reintroduces a user charge for civil and family legal aid, and enables interest to be charged on legal aid debts, Mr Speaker. And our concern is, at a practical level, in terms of people's real life experiences, what we are going to see is that people that earn $22,000 or over, which is really not a lot of money, Mr Speaker, are going to lose what they should fundamentally in this country have a right to, and that is justice. That they will no longer be able to afford it, that there will be cases where, because they can't afford it, they are forced to represent themselves in court, Mr Speaker, and that in turn will increase the chances of miscarriage of justice. So, Mr Speaker, we do oppose this bill, and we hope that our colleagues across the House would see some sense and join us in opposing this bill also.